Good morning, everyone, and welcome to the Appeals Hearing Board for September 18th, 2025. I think we'll just call the meeting to order at 10:01. And the first item on the consent agenda is to approve the minutes of March 22nd, 2024. Does anybody like to?
I move that they get approved.
Okay, can you speak up just a little? I'm not sure.
I move that they get approved.
Perfect. Thank
I can second.
you. Okay. All right. So roll call vote. Just be okay.
Yes.
Okay. Okay, the motion passes 4-0. General public comments at this time. Online. Seeing no one online, is there anyone in the chambers? Doesn't look like there's anyone in the chambers. I think it's okay to close public comments. Okay, and our next item on the agenda is to adopt a regular meeting schedule for the 2026 years.
Move that the existing calendar that's in that document be approved.
Okay. Second?
I can second as well.
Okay.
And there's online that might wish to speak, and there's no one in the chambers.
No.
Okay.
Mic's on? I'm not sure.
Yeah.
I understand that the mics are on.
Okay.
It doesn't sound very loud, but
Okay, so all those in favor?
Yes.
Okay, the motion passes 4-0. Okay, and the next item on the agenda is to select a chair and vice chair for term ending June 30th, 2026.
I'm just the pinch hitter today, so whoever you guys are looking for, happy to support it.
Does anybody want to be the chair? There's a 1 no. All right.
Christine, can an alternate serve as a vice chair or chair? Because we're going to need.
unfortunately not.
so
Sorry.
you guys have to pick it up.
All right. I'm happy to do so.
Okay,
Do we need a nomination for vice chair as well?
we do.
Okay. You guys want to flip a coin?
Happy if you do it.
I'll do it. Perfect.
Okay,
So I'll make a motion that Mr. Glenzer is the chair and Thaddeus will be vice chair.
okay.
I'll second. Or no, I can't second. I'm one. They want to.
You can, yeah.
Okay. All those in favor?
Yes.
Aye.
Okay, the motion passes 4-0. Okay, the next item on the agenda is the adopt administrative order for failure to comply with compliance order issued June 6, 2025 for violation of the Montery City Code Section 9-0.1.10, adoption of the International Property Maintenance Code, and Section 13-0.1, adoption of the California Fire Code, California Code of Regulations 4, and California Code of Regulations 4.
I am going to recuse myself from this matter as a longtime customer of the business. So that's why we have Mr. Cheng here.
So it's not pardon me, it's not a legal disqualification. So Ms. Fritz is allowed to observe this proceeding. You don't need to leave the chambers.
Okay.
But you should probably step down from the dais. And I do have just a quick disclaimer before we get started here. I'm the city attorney. I'm representing the Appeals Hearing Board in this matter. Karen Crotley is the assistant city attorney, and she is representing staff. We have maintained a due process separation wall, meaning that I have not discussed this case with Ms. Crotley. and we have not shared each other's files. I've received the same information as the board at the same time. The board received the information, and we do this to make sure that there is a fair hearing and division internally in our office to ensure that due process is provided. And so the way these proceedings ordinarily work is we will hear from the city's case, and then we will hear from the appellant, and the board can ask questions and then deliberate and render a decision. And of course, it'll be opened up to public comment as well. So, Chair, if it's okay, we can go ahead and let the city.
Just one, excuse me, just one question. My memory from 18 months ago, we used to normally say something about forms of evidence and whether this is legal, that, and
Yeah, sure. So,
Thank you.
the rules of evidence are not strictly applied here. So hearsay is admissible as long as it's reasonable to be considered. So in other words, the hearing is much more flexible than as if we were in a court of law. So much more relaxed standards here. And the city does carry the burden of proof by preponderance of the evidence, meaning like a little bit more than 50%.
I'm not very good with numbers.
Well, if it pleases the chair and the board, I'll begin. I'm Assistant City Attorney Karen Cratley. I'm, as City Attorney Davi mentioned, I'm representing the departments today, which are the Fire Department and the Code Compliance Division. So if it's acceptable with the board, I would ask Rory Lakind, our Code Compliance Officer, and Justin Cooper, Division Chief from the Fire Department, to maybe sit at the table so they could have the microphones and kind of help as we go along.
That sounds like a great idea.
Okay, great. I'll start with a little background, and then they will provide informal testimony to the board as well about their inspections and violations at the property. So we're here today to talk about 1299 Del Monte. So just a little background, because we haven't done this in a bit. So the city code provides for a compliance order to be issued whenever staff determines that a violation of the city code is occurring on a property within the city. And so at that point, the staff can issue a compliance order detailing the violations that exist on the property, and then giving the property owner a reasonable amount of time to come into compliance. If compliance is not achieved, full compliance, then within the time in the compliance order, then a hearing is set before the appeals hearing board. And as we are doing today, staff requests you to issue an administrative order that then includes penalties, costs, as well as a deadline for compliance for the property to become in compliance with the code. So that's the background there. I also wanted to mention the standards. So as we discussed briefly, you're going to consider written and oral evidence regarding the violation. And this takes the form of the agenda report, which you received. Then you can also hear the testimony from the property owner, anyone else that may be held liable. So that's the general standard. And then if you find by a preponderance of the evidence that the violation has occurred and was not corrected within the time period, the court says the board shall issue, the code says the board shall issue an administrative order. So this is the property we're talking about here. That's an aerial view of it, slightly highlighted. And this was also attachment 18 in the packet. And so the city code specifies that property ownership is determined based on the county assessor's records. And so the county assessor shows that this property is owned by Del Monte Investment LLC. Let me try to move this really quickly. So I also included that attachment 21 is the Secretary of State filing for Peninsula Tire Services, Inc., which is the business operating at that location. and that filing shows that it's owned by Anthony Virgil. And the same agent for service address for Del Monte Investment, which it's a little hard to see on the slide, but in the packet, attachment 18 is shown as the owner for 1299 Del Monte. That has the same address as Anthony Virgil and Peninsula Tire Services agent in attachment 21. So staff submits that the 1299 Del Monte property is owned by Del Monte Investment LLC, which is managed by Anthony Virgil, and that the business operating on that site, Peninsula Tire Services Inc., is also owned by Anthony Virgil. Okay, there we go. So, right, yeah, okay. The compliance order can be issued based on violations of city code, and the city adopts the California Building Code, the California or the International Property Maintenance Code, as well as the California Fire Code. So this slide is just illustrating that by extension, the city has adopted these codes, and so then we can cite and issue compliance orders for violation of both. In this case, it was the International Property Maintenance Code and the Fire Code. So then we come to the violations on the property. So these slides show, they were both taken in October of 2024 and show what is referred to as the tire pile on the property. And so at this point, Code Compliance Officer Rory Lakekind is going to tell us a little bit about the inspection process at the property and what he found when he inspected there.
Good morning. My name is Rory Lakekind. I'm the Code Compliance Coordinator for the City of Monterey. I've been employed for approximately 4 years in this position. I received a complaint the beginning of October 2024 about the tires piled up at 1299 Del Monte. I went out to the location with members of the fire department, met with the owner of the property and of the company, Mr. Virgil, and we discussed some of the issues out at the property. They included the tire pile. There were some people at that point living on the property as well. And overall, the condition of the property was not up to the city code or to standards that we expect our businesses to uphold. Subsequently, I sent out a notice of violation to the property, giving, I believe, a 30-day window to clean up the property. Here we are almost a year later, and though we've had a couple times where large amounts of tires were removed due to the fact that it's a business that sells, tires, often 4 at a time, the pile has actually grown in height. So we're still probably somewhere between 1,000 to 1,500 tires stacked up outside the building. The pictures you see are between 2 buildings, which is extremely dangerous for fire concerns. There are tires stacked up inside the building as well. The original use of the property before Mr. Virgil purchased it had qualifications that there should not be tires between the buildings outside. Over the last 11 plus months, I visited the property often with the fire department approximately 17 times. And though the pile has diminished on a couple of occasions, it's grown back up to the other photos you'll see in the slides. During that period of time, I issued some citations, had multiple discussions with the property owner about the situation. And it unfortunately, I believe due to financial issues, he's not been able to remove all of the tires.
Okay, thank you. And I'll just go to the next slide. These are photos taken then in June of this year, June 2025. and maybe Division Chief Cooper, if you could talk to us and explain to us sort of your concerns and why the fire code prohibits large tire piles like this.
Yes, good morning. My name is Justin Cooper. I'm the Fire Marshal Division Chief here with Montery Fire Department. Thank you for allowing me to speak on this matter. First off, as you can see, the height of the tire pile, based upon the rules and regulations in the California Fire Code, which has been adopted, tire piles are subject to requirements being met in the fire code. And one of the particular ones is you cannot have tire piles within 50 feet of a structure or of a lot line. And there's some exceptions in there that could shrink it down to 10 feet. But as you can see, this is all the way up against the buildings, between the buildings, and also against the property line across the setback. If you were to have a fire that ignites in these type of tires, they burn very hot. It becomes a very much hazardous situation for firefighters. If you've ever seen a tire pile on fire before, my knowledge and expertise with fighting these type of fires, and I've gone to some of these before, is we would have an imminent threat of losing both of those buildings, and also potentially the building in the back based upon how close it is to the lot line. You're looking at not just a single 1 hour type firefight to put this type of fire out. This type of firefight, once these tires get involved in fire, could last even over 24 hours of the type of firefight. Obviously, that would also have significant impacts to the city, including transportation. Obviously, Del Monte is a major artery, also would potentially affect Naval Postgraduate School, military base there also for us. The other big concern is the environmental hazard of runoff that we would see with this type of fire. Obviously, we have very strict requirements for our sanctuary and for water runoff for our storm drain system. So that kind of demonstrates the issues that we would face if we do have a fire involved in type of fire pile. Does that answer your question, sir?
Yes. And just for the record, did you inspect the property personally?
Yep, several times. I did meet code compliance and other members of my department, prevention staff. Some of them are here today also down there to inspect the facility. We did go on site and talk about the remediation that needs to occur for the tire piles to get actually removed out of that area completely, because as you can see, it's too close to the buildings. The height is well over the allowable height. Additionally, there's an exterior sprinkler head, which is hard to see in attachment 6, but you can see it right below the roof line there where it comes out to the side. That's also too close to having products to a sprinkler. But several fire code violations were observed on the properties. Some of those were remediated, such as the fire extinguishers were all out of date. The owner did remediate that, was able to eventually get some of the fire extinguishers replaced and serviced and put in place, which was a good thing. However, we still deal with the fire issues as one of the main fire code violations.
So based on your inspections, you would agree that the tire piles, both in their locations, dimensions, height, and volume, all violated the California Fire Code? Okay. So moving along, sorry. There we go. So Officer Lakins, sorry, on the left, attachment 14, and it's hard to see, but it is full in the packet. Is that the detail where you mentioned the 17 inspections you performed on the property?
Yes,
Okay. And then we see attachments 9, 10, and 11. Those are all administrative citations you issued to the property, correct?
that is correct.
And was compliance achieved after any of these inspections or administrative citations?
No, the property remains out of compliance.
Okay. Sorry. So then the compliance order was issued by you, correct?
Yes,
And so that was issued on June 9th, 2025. It included violations of the city codes that then adopt the International Property Maintenance Code and the Fire Code, correct?
yes,
And if you look at attachment 20 in the packet, so that is a letter that you sent on July 16th, 2025, and you gave an extension to the property because there had been, it says there was 500 tires removed. Is that correct?
that is correct. There were two incidences where approximately 500 tires were removed.
So in an effort to work with the property owner, you gave him additional time to remove the remaining tires to August 15th, correct?
That is correct.
So then, did you re-inspect the property on August 18th, 2025?
That is correct.
And attachment 19, which is on the slide here in front of us, is that a photo from your inspection on August 18th?
Yes,
Okay. And so at that time, did you observe, in addition to there being used tires stored in the pile, was there also general trash and rubbish stored there as well?
yes, there was a bunch of garbage thrown up onto the pile.
Okay.
Not sure why.
And at that point in time, again, was the pile over 10 feet high?
Yes,
And it was touching the buildings as shown in this photo?
yes, that's an accurate depiction of the situation out there.
And would you estimate, based on your inspection, that it was over 1,000 tires at that time?
Yes,
Okay. So based on the city code, staff also requests, in addition to finding that the violations were not remediated, that they continue to exist. And let me back up one more. Officer Licken, did you drive by the property today?
I did not get there this morning.
Okay, but this week, I believe?
Yes.
And was the tire pile still there?
Very similar.
Okay, thank you. So in addition to finding that the violations continue to exist, staff also asked that the Appeals Hearing Board assess administrative costs. So these are the costs of the inspections, both by code compliance as well as the fire department. And those itemized costs were included as attachment 14 in the packet. And up here, I put the city code section that authorizes the board to impose the costs. We also request administrative penalties. So this is a penalty of $10 a day for noncompliance since August 15th until today. And then we would request additional penalties of $50 per day if the deadlines in the board's administrative order are not met. And the city code authorizes those penalties to accrue up to $100,000. So I would also say, as Division Chief Cooper mentioned, the fire extinguisher violation has been complied with. So I did provide an updated draft administrative order that I brought with me today. I provided one to Mr. Virgil and can give one to the clerk and the board. The only change from the one in the packet is that the fire extinguisher violation has been removed from that draft administrative order that staff has requested be adopted. So in conclusion, the tire pile continues to exist. Has a total of approximately 1,000 to 1,500 tires in total. It presents a highly hazardous kind of threat to the community there, given the flammable nature of used tires. And so staff requests that the administrative order as revised today, and I'll give one some additional copies to the clerk, be adopted. And with that, we can have any questions from the board. And then Mr. Virgil will also be given an opportunity to cross-examine staff if he wishes.
Just a couple of questions. What exactly is the difference between a citation and a compliance order?
So the city code allows for different enforcement options for staff. So an administrative citation is, I would describe it as akin to a parking ticket, where you pay a set fine and essentially that's done. So in those cases, I think it's a couple $100s here. The compliance order is not just looking at retroactive. It says you have to take remediation to clean up the property. And if you don't, you can potentially face fines and penalties. And there's also the possibility that the city may abate the nuisance. And obviously there'd have to be another hearing, but lien the property then for those costs. So generally a compliance order and administrative order is more serious than an administrative citation.
Okay. And I want to check my understanding. So there was a compliance order issued on June 9th, and then there was another one issued on August 15th. Is that correct?
So a compliance order was issued June 9th. A new one wasn't issued, but we extended the deadline in the June 9th, because originally I think it was a 30-day, sometime in July that the compliance had to be achieved. Staff had seen some steps towards compliance, wanted to try to work with the property owner. And so they said, we'll extend the deadline for compliance. So it's still one compliance order though.
Got it. Very, very broad question about all the procedures that have been followed. Fire department, yourself, sir, the city. Is there anything unusual about this whole procedure? Anything from the city's perspective that was somehow different from a normal, whatever a normal procedure is?
No, we haven't specifically, at least in my tenure with the city, dealt with a tire pile, but we've dealt with other forms of nuisances, rubbish, garbage, trash accumulating on properties that then is not cleared out, and similar process has been followed for those properties.
That's all I have.
Corinne, for the record, could you walk us through exactly how much money you're asking for and break it down?
Sure. So let me go back real quick to. So the administrative costs, which is the cost of the various inspections, mostly staff time.
Yeah, I just meant there's a $10 or $50, then the admin cost of $73.
Well, okay, the penalties.
Yeah.
Okay, yeah. So the admin costs that we're requesting are $7,339.92. Then the penalties is $10 a day for 34 days, which is the time from the final compliance date of August 15th until today. And so that's $340. And then today, if the board imposes as an administrative order, you would adopt a deadline in the future for compliance. Staff proposed 3 weeks to remove the tires. If that isn't complied with, then we would request further penalties of $50 per day.
The citations on attachments 9, 10, and 11, have those been paid?
No. At least not the last time staff checked.
Okay.
Mhm.
I was reading through the citations and the specific order. At what point, and this isn't as a matter of law, but more of a matter of equity, at what point was the gentleman given notice that administrative costs might be at play?
As far as citations,
Yeah.
immediately. I've hand delivered multiple, documents to Mr. Virgil. I've spoken with him on at least 17 plus times. He was notified multiple times that, citations were going to be issued if things weren't done. We're at almost a year
One of the compliance orders specifically identifies that administrative costs could be at play.
It's in the documents.
Yeah. At which date?
October 8th, October 10th, 2024.
Can you point me to that attachment, please?
So it's attachment 8. So that's essentially, it says at the top, warning letter. So no penalties were imposed at that time, but it does say, failure to correct may subject you to administrative citations, fines, liens, and other legal remedies. And it also details that a compliance order may be issued. So that's on packet page 29.
Yeah. And just to double check, when are we starting the clock on administrative costs? Is it after October 8th or?
So that is attachment 14. Let me look here. So attachment 14 shows administrative costs and it goes back to October 8th. So, of course, the board has discretion to decide at what date and adjust costs or penalties as you so see fit.
Yeah. What happens in terms of the unpaid citations? Does that move forward as a lien or does that get wrapped into this?
Those are a separate proceeding. Generally, the finance department can decide if they want to attempt collections through a collections agency or small claims court. But that is housed within the finance department.
I don't want to monopolize the time. So Thaddeus, you got questions? I want to.
Yeah, I just have a few questions. How do you know how many tires are there?
Just by looking at the volume, I believe Division Chief Cooper did some research.
Yeah, looking at the volume and size of the pile, and looking at a distance measurements of the tire pile. And then looking also at how many tires were removed by the company when he did have about, it was 500 tires removed. Of what that did as far as reducing the pile. It was easy to take a look at it, that there's well over 1,000 tires located in that tire pile.
Okay. Has there been any other complaints besides the one initial complaint you received?
Yes, there has. I have received at least 2 different complaints to Montery Fire Station 13 from citizens that have actually come to that station at various times to complain about the tire pile there at that intersection. And that was reported to one of the fire captains there, Fire Captain Danny Gibbon, who then actually took initial action because he did not know that we already had a complaint on this before. We were already in this process. But he actually drove over there to the pile, and then he also did send me an email raising the concerns about the fire threat and hazardous conditions that were occurring on the property.
Okay. The last question, what I'm a little not clear on, and this just be my naivete, I've not been on this committee, but it says you went there 17 times. It just seems kind of excessive. Like I'm not understanding what you thought was going to be different. And then just to follow up on that, so then does he get billed an administrative cost for someone going to his place of business for 17? Is that part of the administrative cost, going to the business 17 times?
So staff is requesting that to be imposed. That's what's itemized in attachment 14. I would say Monterey generally has a history of trying to work with property owners to achieve voluntary compliance. And I think that was what was done in this situation. Now, of course, the board has discretion if they want to reduce that amount and find that maybe you feel some of those were necessary or unnecessary. But I believe they were trying to work with the property owner towards compliance.
We can craft remedies. Okay.
Thank you.
You're welcome.
So now I have a follow-up based on that. Had the original compliance order, June 9th, been met, would there still have been administrative costs then?
Yes, if you look at attachment 14, well, okay, no. If the compliance order was complied with, then we don't have the hearing and no administrative costs are imposed at all. Sorry.
So just to clarify that administrative costs can only be issued if it comes here.
Correct.
I'm sorry, but I didn't hear what you.
Administrative costs can only be charged if it comes to this board. They can't just do it on their own.
Right. It has to be part of the administrative order, which is issued by the board. So with that, if Mr. Virgil, would you have the opportunity to cross-examine the city's witnesses? Or you may do your own presentation, however you would like to proceed.
Hello, Paul.
Hello.
How are you? Anthony Virgil, Peninsula Tire Service. Yes, the officers and fire department has been out there all those times, and they've been really trying to get me in compliance. I'll say that right off the bat. The problem is that I had some banking issues in the sense of funds that I didn't have. So that's how they, and I mentioned it to the, I'm a straight shooter. I tell you how it is. I just didn't have the money to get those out of there. After it was aware that there was way too many, I had some tire disposal folks come by and we got it down, and we got all of them out of the most of them out of the because there was more than that. I mean, I hate to say that there was. What I'm just saying is that I'm working on it. I will get those out of here. Just 3 weeks, I will have. I sold the property, because I was going to be foreclosed. Had to sell. So when I get those funds, I'm going to, clean everything out, and there will not be a Peninsula Tire. Yes, I'm out of business. And you're right. I had a lot of tires out there, and they. I don't really have too much more to say than that. I will clean up the mess. And I have taken steps to do that. But then again, like you said, you get, I've been there a long time, and I got a pretty good clientele. And of course, you can dispose of some, then some come back, and then you run into an issue of it looks better, but it's not in compliance. And I agree with that 100%. Like I said, I had these real bad loans, and I had to sell the property. They were going to foreclose. I just couldn't afford it, and I was just, and that's truth, and that's what's going on. I'll get them out of there, and I will make sure it's all cleaned up before the next session of the problem.
Mr. Virgil, you okay answering a couple questions, or?
Oh, yes,
Okay.
Yes.
Did you say that you're selling the property?
it's been sold.
The property has been sold already. So you, through your LLC, are no longer the owner of the property?
No.
Has that title transfer already happened, or?
Yes.
It happened. Okay.
Yes.
Okay, I'll find out.
Oh,
I don't have any other questions.
I'm sorry to hear about your loss of the business. You're selling the property, your loss of your business. Are you moving the business? You're moving your business someplace, or?
no, but they're close that. Actually,
So how much longer do you think you'll be There.
The 3 weeks. Might get that.
Is your business currently renting the property from the current owner?
Actually, he just gave me time to
Okay.
been very generous on that, just to give me a little time to take care of the tires and just to clean property up.
How long were you there?
31 years, sir.
How long?
31.
31 years.
Yeah.
Oh, wow.
I don't have any other questions, you guys?
I don't have any questions.
Hey, thank you.
So at this point, let's have a conversation about what we're thinking about this.
Yeah, if we could just check to make sure there's no one in the public that wishes to speak on this too, that'd be.
What a great idea.
Yeah, thank you.
At this time, there's no one online. And it doesn't look like there's anyone in the chambers either.
Christine, does the city get a response as well, or are they okay?
If they would like to, sure, yeah.
I'll just, so the city obtains property ownership information from the county assessor's database. And I will say that does not update quickly. So I don't have confirmation on the sale, and I have not seen any documentation on that. So I don't have any further information to provide the board on ownership.
Is the citation attaching to the building or the property or the business itself? That's going to be important.
So the administrative order, you can determine who the responsible party is. And a responsible party can be a business owner, a property owner, or both. In this case, based on the evidence the staff had, we put before the board that the responsible party is the property owner, the business owner, and Mr. Virgil as the manager of both of those. Staff does not actually lien a property. We don't have authority to do that, and neither does the board until we were to go to the city council and ask them to do so. So that's another step. So that would not necessarily happen regardless of what happens here today.
Does anyone have a relationship with Marina over at the assessor's office?
No.
No. I was saying if we could maybe find out, wouldn't be too hard. We have an APN, they can check pretty quick whether like a change of ownership has come through.
Mm-hmm.
Or if the sale was just like a private quitclaim deed. I'm just trying to figure out whether sales really happened.
Mm-hmm.
So. Okay.
All right, let's open this up for some deliberation. Thoughts?
My analysis doesn't necessarily center around matters of law. The violations seem pretty clear. The procedure seems to have been followed. Due process seems to be followed as well. Lots of notification. So sufficient notice. Like all those principles seem to be met. I think the majority of my discussion will be centered around crafting a proper remedy, something that feels right, seems right. How do we balance compliance, justice, and not being punitive? That's sort of what I'm trying to figure out here.
Mhm.
Or if the board wants to be punitive, that's for everyone to, that's why we're here as citizens, is to get a proper sense of that.
I would echo those comments. I briefly said, I think everything was done. On the I's have been dotted, the T's have been crossed, and it's just about what is the what are we gonna come down to as actual remedy? I'm a little, like, the administrative cost, I'm not sure about going that far with that number. It seems a little high to me. Especially, you keep going this way, the situation. I understand the desire to work with the owner. But if the situation does change, I mean, I'm not sure you can keep going someplace and then billing someone for that, saying, hey, we're coming by here. And I understand the idea of wanting to work with someone. But I think for me, I have flexibility in that number and changing that. But again, ultimately, whatever we come with, what is the end goal? Is the end goal to try to make it whole? Is it to ensure that this doesn't happen again, or is it to protect the general public? We're in at least for me on charter church because it's kind of a different situation where someone has actually basically shut the business down. My understanding is that this is shown with the record that he has moved on this way. So I don't know. I'm more looking at what the in game, what the remedy would be,
And I'm sorry, go ahead, Justin. No, go ahead.
Christine, do you know how common these administrative orders are that add cost?
I will say lately, as we all probably know, the board hasn't met super frequently.
Yeah.
Administrative orders over the time when it was rather regular, probably a correlation between our short staff and on the code enforcement side. But yes, it's difficult.
There's always the concern when it comes to issues like this about incentives. We don't necessarily want to incent the piling on of costs if we know that that's always something to keep in mind.
Well, what would
The administrative costs seem like, just from my gut feeling, the administrative costs seem high, the fine seems low. So a rebalancing of those might be the way to go.
what thoughts do either one of you have about a rational way of perhaps modifying those administrative costs? That's what I hear both of you saying.
That's
So
actually just where my discussion would want to be centered. And I want to get a feel from the rest of the board. I'm actually not adverse to the number itself, but I'm aware that it might be high. So that's why I raised the issue. I want to bring it up for discussion and get a sense from the community as to how you guys feel about it.
Thaddeus, do you have any?
I mean, to me, it seems a bit high, but I'm trying to think, what would be a logical way to reduce, as opposed to, oh, that's too much, I want to reduce it by 10%, 20%. But what's the reasoning? What's the support of why you would do that? I guess that's the challenge I'm coming up with. Is there a delineation someplace in this process where I say, oh, well, maybe at this point, we should have just moved and gone and taken action or going forward. But why are we still, each time they come by, it's another hit. It's another cost. So should the city at one point just stop and say, hey, let's move on to the next?
And the city is balancing, trying to work with owners.
Yes, no, I get it. No, I'm with you on
I
that.
know we all get that.
But it seems like you're being, they're trying to give you a break, but them also not giving you a break, you're also getting hit with this number each time they come by.
Yeah. So one way of, so anyways, I'm sympathetic to both of what you've said. Clearly the procedures were followed. Clearly Mr. Virgil knew all about this all along the way. And then this question of rectification in some way, shape, or form, and punitive in some other way, shape, or form. I agree with all of what you're saying. And I also just want to commend the city for how much you've done here, how much you've tried to work with Mr. Virgil. I just think it's really admirable, right? It's the kind of city I want to live in, right? I don't know, one way perhaps of doing something logical here, it's the first thought that I have. If the three of us are circling around this, I mean, one way would be to start the clock on the administrative costs on June 9th, not October 8th. June 9th, when the compliance order was actually issued, which is as Assistant City Attorney Karen, hope you don't mind if I call you Karen. Had mentioned that moving from citation to compliance is a big thing. It's a big thing. It's moving from a parking ticket to, something a lot more serious. So it's one way that I think that we might, as a board, might be able to think about it that way. That, yeah, I mean, I think some administrative costs are proper in this case. So that would be one way of perhaps reaching a conclusion that seems somehow based in some kind of facts.
I don't have a spreadsheet and a calculator. Make someone get the number.
I don't know what that number would look like starting the clock on June 9th.
Attachment 14, page 72.
Yeah, I'd be fine with starting the clock on June 9th.
Happy with that.
I would be very happy with that. I mean, I don't know what that number is. I don't know if we, Christine, do we have to know the number in order to?
Calculating it right now.
Corinne, does council have any issue with that for the city?
Obviously, it's the board's prerogative. I mean, staff.
Sure.
That is within our ambit.
Suppose if they have any input.
Yeah.
I would just clarify, staff's main concern is compliance. And the business, as far as staff is aware, while the property may have sold, the business is still operational. And so tires are still being taken in on a daily basis currently. So waste tires continue to accrue. And so achieving compliance and getting that to stop and then cleaned out is staff's primary goal.
Yeah. And yeah.
I don't know if we can do this, but everything I am deciding is kind of premised on this belief that the property has been sold. And so I don't know if we can hold our opinion and stay our opinion until this is verified, because everything I'm going with is that property has been sold. And that this will, my understanding, cease operation. So that's kind of what the backdrop I'm working with, but that's not the backdrop I'm working with, and I may make other decisions. So I don't know if there's a way that we can write an opinion and it's based on this actually happening.
Christine, could you advise us on what would happen in terms of a continuance or anything like that?
Yeah.
Yeah, you could continue it for proof of sale. Ms. Cratley did indicate that the code provides under section 1-2.15 that the compliance order may be issued to any person responsible for the violation or the property owner. So how much the ownership falls into this equation is up to the board, but it could be 100% against the property owner, the business operator, despite the ownership issue. So, but if it is playing a role, we could certainly continue this for verification of the closure of escrow and the transfer.
Hey, Thaddeus, how would it, and you don't have to answer, but I was just curious, how would that change your analysis, you think, if he was still owner or not owner?
I do think I might be because I guess the thing is, part of how I envision it is more than I need to make sure this doesn't happen again. How do I ensure that this does, what powers do I have to ensure this doesn't happen again? I don't have, apparently from what I'm hearing, I don't have to worry about that now of this happening again, because it seems like the problem has resolved itself. So then I can go from this problem being resolved. So then how do I try to address the issues that the city has brought, and also address the issues that the business owner has brought? How do I try to fix that problem? I don't have to worry now. Going to get more complaints from people. We're going to have this fire that I'm concerned about, and this other harm. I don't have to worry about now. I just got to solve this part of the puzzle right here.
Except for the next 3 weeks, according to the compliance order.
Yes,
There's a 3-week window to actually get the fire hazard and
correct.
potential harm to the environment and the neighborhood and so on and so forth. So it's a window of 3 weeks, one way or the other,
Yes.
no matter who, right?
Do you have any thoughts on how you want to go with it?
Well, I would be fine moving forward with starting the administrative clock on June 9th, and I would be fine because of the ambiguity about ownership, that the responsible party be Mr. Virgil and not whoever it might be, the new owner.
I'm okay with that, but I just want to make sure that's,
So I'm double checking my math because I got two different numbers on each calculation. So I'm just doing this again a third time to see if it hits it this third time. Sorry.
Is it possible this calculation maybe should be formalized somewhere outside of this particular event right now? It's a question, Christine.
We could fill in the blanks later. It's probably under $3,000. Let me just check it one last time. But yes, we could confirm it again outside of the proceeding.
my only concern with doing that is if Mr. Virgil decides to bring the case to Superior Court, it's gonna be based on whatever order we give. So if we give an order, his next level of recourse is to go to court, if he chooses to challenge. So I would think if we have a properly crafted order, that's what we'd want. If we end up making an order, as opposed to continuing.
I can see if this matches any of your numbers, but the number I got was $3,368.68.
I have now gotten that same number twice.
Okay.
So I've gotten 3,368 and 68 cents. Is that what you said?
That's what I got.
All right. So I've gotten that twice. So I think that, and you've gotten it once. So that's correct.
So we're essentially, as a board, however it ends up getting formally put into this, we're agreeing that we'll take a vote, but we're agreeing to start the administrative clock on this issue on June 9th. And as of I think it's the date of this hearing that additional, if within 3 weeks, there is no action, then we move to the $50 per day after the 3-week period. We are confirming the $340 in citations, or I'm sorry, it was the daily going back 34 days to August 15th. We're affirming that that is something that we support. And that's what we're talking about.
340 with the 50 on the other clock and 3,000. That's
So just to make sure I understand,
clear.
administrative costs will have been accrued starting on June 9th.
Correct.
And we determined that amount is being reduced accordingly from $7,399.92 to $3,368.68. That's for administrative costs. And then for the penalties, you're confirming the $340 in penalties.
Yes.
Okay. And if these costs are paid in full, in this proposed order, we have a deadline of October 31st. Is that date staying the same?
Yes.
Then the $340 will be waived. That's what the proposed order says. So it's like, it's charged, but if,
Gotcha.
if
That's what the proposed
the-
order says.
the $3,368 is paid by October 31st, 2025, then $340 will be waived. If full compliance is not achieved by the deadline, then these penalties will be immediately due and owing. And then if full compliance is not achieved by October 9th, does this board agree to increase the penalties to $50 per day?
I think that's would be a good thing.
Okay.
I agree.
Okay, and so maybe as a part of the motion, there can be, I've heard you all discuss this and say this, but confirmation on the factual findings, the penalties and costs and deadlines as I've just described, and that you would in addition authorize the board chair to sign the administrative order as set forth in the motion and with the modifications I described.
It's a mouthful. But
It is a mouthful.
I'm ready to second it if someone says.
Let's see. So we are agreeing to start the administrative clock on June 9th for the amount that we've just discussed. We have agreed on the $10 times 34 days that will be waived if if Mr. Virgil achieves, I guess, full compliance and pays the administrative costs, that will be gone. But if after the end date, full compliance hasn't been achieved, then he will start accruing $50 a day in non-compliance. And we're agreeing that I can sign the order once it's formally written, because it'll need to be rewritten.
Right. There is a draft in attachment 16 that was updated by the city and distributed this morning. And then I will make the additional edits as described today for your signature.
Right.
Second.
All in favor? Aye. Yeah. Anybody opposed? I don't think so. All right.
Okay, it looks like the motion passes 3-0.
Thank you. And I think with that, we can close. Sure.
Board member comments. Does anyone have any comments they'd like to make?
I wish you luck, sir.
No comment.
Okay, looks like we are adjourned at 11:05.